All right. Welcome to The Detail. I'm your host, Cathy Antunes, and you are listening to The Detail on WSLR 96.5 LPFM in Sarasota, Florida, and WBPV 100.1 LPFM in Bradenton, Florida. Well, Lourdes Ramirez is my guest today. Lourdes has been a longtime advocate for smart growth policies and particularly a very effective advocate for preventing over-development on Siesta Key. Lourdes has run for county commission. She is the president of the Women's Republican Club in Sarasota County. She served as president of the Council of Neighborhood Associations. When I was vice president, we were there together. And you have been president of the Siesta Key Association. I'm sure there's a lot more with a career in the semiconductor industry, in sales. Lourdes is somebody who impresses so many people with her ability to grok lots of technical information and then translate it and explain it to her neighbors and advocate. So Lourdes, thank you so much for being with me today. I appreciate it.
Well, thank you for inviting me.
Yeah. So we're here because you have filed a legal action. You filed it against Sarasota County. You've got more than one legal action going on related to this issue. And you also filed against the Department of Economic Opportunity in the state of Florida. This was to stop the proposed hotel development in Siesta Key and very importantly, to question what looks to be a complete violation of the comprehensive plan. And this week, a judge found not everything that you asked for, but I would say one of the very key findings was in your favor, that the county did indeed violate the comprehensive plan with a new ordinance. I'll let you tell the name and the number and what that ordinance said, but this ordinance basically opened the door for what's being said locally, mega hotels on Siesta Key. So big legal win, not the end of the story. You've got a long way to go still, but can you let's just start off with what was the new ordinance, Lourdes, and why was it problematic?
Yes, the new ordinance was adopted in 2021, October 2021. And the purpose of the ordinance was to eliminate density maximums for hotels anywhere in Sarasota County, so that hotels are only guided by the footprint and not by the number of rooms. And that is problematic for barrier islands because we are not only the most attractive places for hotels, but also the fact that we are already highly intense already on the barrier islands, not only for traffic, but we have a lot of people out here. Yeah. And to add more people, having unlimited number of units is going to cause a lot of problems with hurricane evacuations, traffic, noise. Yeah. Previously, for example, and I think the example would be is previously the maximum was 26 units per acre for a hotel.
For a hotel. So we're talking, and density is that per acre metric. Usually in land use, you're talking about how many units per acre. With hotels, it would be how many hotel rooms per acre. So it was allowed 26 units an acre if there were no kitchen, right?
That's right. If you had a kitchen, it was less, 13 units. Mm-hmm. And by eliminating that maximum, the hotel developers turned around and proposed different hotels on Siesta Key. And the one I was fighting was given 170 units per less than an acre. It was 0.96 of an acre. Mm-hmm. So you went from 26 to 170. And that's a huge problem for us on Siesta Key. You know, there's a lot of people coming in, and this is people turning over the rooms frequently. So you have a lot of new people coming in and out. And we were really worried about the impact. And that was one hotel proposal. And we know there were 4 in total before the legal challenges started.
So we're basically saying, roughly a 700% increase in density, right?
Yes.
Going from 26 rooms an acre was the maximum that was allowed. And then it just shoots up in October 2021. They approved this huge increase for this one hotel to 170 rooms. So I'm trying not to keep it too technical, but we can't avoid it entirely.
Right.
Siesta Key, this was an ordinance that was focused on in a land use category of CG zoning, commercial general zoning. And it's my understanding, reading the order, and actually saw part of the hearing that was held in December, I believe it was, and heard some of the arguments that CG zoning uniquely impacts Siesta Key. It is the only barrier island with CG zoning. Did I understand that correctly?
Yes, in the unincorporated Sarasota County, we're the only one who has CG property. It's Casey Key, Minnesota Key they're all residential. They don't have any CG parcels on it. Mm-hmm. So we were the only barrier island on the unincorporated Sarasota County to have a commercial general district, and 2 on our islands.
So the incorporated, what we mean by incorporated is Lido Key and St. Armands are with the city of Sarasota. So the county does not have jurisdiction over their land use decisions. In fact, it's the city of Sarasota, and which, the city of Sarasota is, there's a lot of concern about development in the city, but I think there's still have a more responsive ear to residents than the county does. And then Longboat Key is an incorporated. So it basically means they're a city, and they also make their own land use decisions. In fact, when this decision came down, I don't want to get too far off the track, but incorporation was and may still be seriously considered by Siesta Key to avoid the abrogation of, what the county has done, just opening the doors to just huge hotels. If Siesta Key were its own entity legally as a community, if they were a city, what are the chances this would have gotten approved, Lourdes?
I don't believe that. I know that if we were our own city, this would not have been approved. We would have looked at the impact of hotels that large would have done on Barrier Island and on our islands, and say, no, we don't have the infrastructure or the capacity to add that many more people. We probably would have allowed a 26-unit hotel, boutique hotel, sure, but not anything so massive.
Yeah. So, this was an interesting case to watch the arguments. And I have to say, I can't believe it's been 15 years, but it's been 15 years now that I've been watching hearings, land use hearings in the city, in the county. There are many times, and I know obviously you understand this, where you'll listen to the applicant for a project and they'll be saying things that are just, you'll be sitting there pulling your hair out. The equivalent is, the sky is black instead of blue. And everyone's serious, like, oh yes, the sky is black instead of blue. And I was watching your hearing, and that's exactly what was happening here. And I just have to say, it was so amazing to read this order and go, oh, thank goodness, there's a judge who's telling them, no, what you're saying is illogical and unreasonable. The part that you won on, can you explain to people exactly what I'm referencing here, where the county violated the comprehensive plan?
Yes, the comprehensive plan made it very clear that when it comes to all of the barrier islands, they kind of froze our zoning as of March 2021. 13th, 1989. So anything that was built or approved or even allowed in March 13th, 1989 can still go forward, but you can't add any more density or intensity. And then they go make this change that added more units to Siesta Key in violation of those growth plan policies. And that's what I sued on. I said you couldn't change a code and add more units on a barrier island when we have a law that says, because comprehensive plan is the law that says you cannot increase the density intensity as it existed in March 13th, 1989. So the developers were trying to convince the judge that this was allowed in March 13th, 1989. And they did that by trying to change the interpretation of what was allowed at that time by saying, and I know you and I talked about these intensity bands, and do you want to go a little bit into that as well?
Yeah, I actually do. And for the benefit of those who may watch this on YouTube, I'm going to reference a particular document that actually was created in 1981, but in terms of the hocus pocus type of claim that was being made, it was pretty crazy to me, because essentially the county had categories of what, people in development speak will talk about the flume. Oh, the flume says this, the flume says that. Well, flume stands for future land use map. And so what we're looking at is the future land use map in June of 1981 for Sarasota County. And there's all these designations for intense development in places where you would expect. These are, in the cities like Venice, the city of Sarasota, and then out from those intense, and they're labeled red, out from those intensive centers, there's actually, grades of orange and then light orange and yellow showing a reduction in intensity until you get to these green areas like east of I-75, where, at that time, there was no plan for intense development. So Lourdes, explain the logic they were trying to use using the future land use map to tell the court that there were no rules and you could build whatever you want on the barrier islands.
Right. So as you were showing in this map, the whole premise of the 1981 map was, okay, you had a very highly dense core, and then you just get less as you go out, as you showed by the different colors there. And the 1981 map says, well, anything within those areas, the dark reds, the highly intense center of these urban areas, you could have a picture density of, I think it was 36 units per acre, but then you get less as you go out. What the developers were saying, well, that's true. You had density limits within the high intense urban areas, and you got less as you go out, except when you get to the green areas, the barrier islands and the rural areas, there was no maximum density listed. And if it's not listed, that means you can just build whatever you want.
Yeah.
Because they were saying if it's listed, then that's the density. If it's not listed, there is no density.
There's no rule. You can
no
just
rules.
You want.
You can build whatever you want. And that wasn't the intent. The intent was to say we have maximum densities within the core, and outside of that area, you can't build it. And but they try to switch it like, no, that means unlimited. You can build whatever you want. There are no limits. And that's contrary to growth planning.
Yeah. No, yeah. And it in reading the order of the court, it was actually very heartening in a way, because I thought as I was reading it, wow, there really was a time when Floridians and Sarasota County were serious about protecting the environment. There really was a time when we said, we're not going to overbuild on barrier islands. And that time was in the 80s. And as you mentioned, there was a drop dead date. Was it March of 1989, where the county drew a line in the sand and said, we're maxed out. This is in 1989. So
Right.
what, over 30 years ago, we're maxed out. You can have new development, but it can't be more dense or intense than what the rules allow now. That's it. No more. And to watch the attorneys during the hearing, I didn't see the whole hearing, but I was able to cover a pretty substantial portion. To watch the arguments and listen to the arguments being made that no, there is no line in the sand. No, that's not what they really meant, was just, it was pretty jaw-dropping for me. And to be clear, Lourdes, your action was against Sarasota County and the Department of Economic Opportunity, which signs off on development plans. But it was also, there were interveners, those who want to build these hotels, also were part of the lawsuit. So they were also making arguments too, right?
Yes, actually, they made the majority of the arguments. The county would do 25% of the arguments, and I think the developers, also known as the interveners, did 75% of the arguments during the hearing.
Mm-hmm.
And I think my biggest concern at the time was there's such a, as you know, I did this legal challenge with the state on the zoning ordinance itself. The fact that the county changed the code to allow hotels to be approved under this new revised version of what hotels can be built at, what maximum density.
Mm-hmm.
And then, of course, I have the court case that actually challenges the approved hotel itself. My concern was in the state level, and I have to admit I was a little nervous about the state level, is that they have a different standard of reviewing challenges. They have something called fairly debatable. So they give credence to the local government, believing that the local government knows what they're doing. And if there's a fair debate of what the county says is the interpretation of the code and versus what I said, they will give the credit to the county, or they'll give the ruling to the county. So under the court case, which is the approved of hotel case, it's strict scrutiny, which means exactly the way it's written is exactly the way you have to interpret the code. So I was a little nervous about the state case because that's fairly debatable. When they were coming up with all these arguments and
Mm-hmm.
different interpretations, I was concerned that the state can actually say, okay, it's possible. It's almost like reasonable doubt. It's possible that the county may be right in their interpretation. So when I got this ruling, and especially when they start saying it's not credible, some of the expert testimony.
Oh, we have to talk about that, because I love some of the language this judge wrote. Yay! Somebody's saying this is crazy in a very legal, polite way. So yeah, she, what is the name of the judge again, Lourdes?
Suzanne Van Wyck.
Okay. Yeah, no, some of the stuff was golden. I was just reading it going, thank God somebody is actually calling a spade a spade. Yeah, so to your point, there's more wiggle room at the state level if there's a reasonable argument, or if something is fairly debatable, if the language isn't extremely clear. And what the judge found, which I think any reasonable person would find, is that the language is really clear. It's not.
Yeah. That's what made me very happy about the ruling. And because I feel it was very clear, but you never know what a judge thinks. And so when we got the ruling and the decision, and it was I did challenge several policies in the comprehensive plan, saying the county violated, I think, 6 or 7 policies, and she agreed that 3 of them was violated. It was just a relief that someone believed me.
Yeah, well, we are living in times, I think, politically where you kind of wonder, am I crazy? Because this just doesn't seem right about a lot of things, it's a challenging time. And I have to say, Lourdes, there may be people out there who think, well, this association helped you, or that neighborhood group helped you, or she must have some nonprofit or something that's been, that's not, well, you may have a nonprofit to accept donations, but the reality is the plaintiff was you did this on your own, and you didn't get a lot of help actually from associate or people that you would think, not people, organizations that you would expect would be on board.
I did approach a couple of organizations, the Siesta Key Association and the Coalition, to see if they would help out, because I know that they were a part of the county commission hearings, but they were too nervous to do any legal challenge, much less even help and support my efforts. So I was on my own, but I have to thank all the individuals who came out. It was the individuals who came out and helped me financially with this legal balance, because it was it's not cheap to run a legal challenge, especially two. And so it was the individuals out in Siesta Key, and even countywide, people sent donations in to help out. And so those are the ones I really appreciate. And I know the association, the coalition, was too nervous. Mm-hmm. It was a financial risk if I lost. Mm-hmm. And they didn't want to be a part of that. So not one word of advice or one dime was sent, because they were too concerned about being a part of it.
It isn't a small thing to engage in litigation against the government, right? Although these days there's so many things happening that don't make a lot of sense. For an individual to do it is daunting, and yet to have standing with land use, it often does have to be an individual who comes forward and says, hey, wait a minute, I don't think that you can do this under the law. Can you describe a bit about the issues that you encountered with the challenges to your standing? Some of it was pretty crazy, wasn't it?
Yes, I had to, besides showing maps of where I live, close proximity to the location, and then they wanted to have my cell phone to track where I not only where I live close to the village, or do I go to the village because that's where the hotel was, but even if I go off and on an island, as I claim to do.
Wow.
God knows. And there was that one challenge, whether or not that my husband, whose name is listed on the deed, is, do I live here? I mean, it was a little crazy.
Yeah, her husband owns the house. So that means little old Lourdes can't have standing because her name's not on the deed. I was like, you got to be kidding me. There, you're married, you live there. How long have you lived there?
24 years.
Yeah. Okay. Right. So that didn't go. So it was very, your standing was clearly recognized by the judge. She goes into a lot of detail about where your house is, how far you are from Siesta Key Village, which has seen, a lot of intense development since I moved here. I moved here in 99. So you were just before me. And she makes it very clear that yes, this is a substantially affected person, and she does have standing. And she didn't talk about your husband or the deed to your house or anything like that.
No, she didn't.
Yeah. I thought
just the fact that I live on Siesta Key, and although she did talk about the proximity of where I live, 0.1 of a mile. Just the fact I live on a key that's substantially affected. The key itself is substantially affected, and I live on the key. So yeah, it goes to say that I'm substantially affected. Yeah.
So I want to circle back because, these cases can get pretty technical. That commercial general designation was an important part of the basis for the ordinance. It was this ordinance that was passed to allow greater hotel density What was argued by the respondents, so the county and the state and the interveners, who were the hotel developers, was that, well, this really isn't just about Siesta Key, because this ordinance impacts commercial general, and commercial general zoning is all throughout the county. So, you can't say it's just about Siesta Key, because the increase in hotel development can happen anywhere in the county. But as we talked about in the beginning, the reality is CG zoning in the unincorporated county is only for the barrier islands. Only Siesta Key has that zoning, right? Of like Minnesota and Casey Key, they don't have CG zoning.
Correct. Yeah.
Okay.
Yeah.
And so what I really loved is also is that the judge talked about the hotel proposals as a result of this law. Let's take a look at the hotel applications since the law came in. You're saying it's really not about Siesta Key. Who's applying to build hotels? And tell us about that, if you would.
Yes, the county argued that there's 5,200 acres of commercial general zoning throughout the county, and most of that is outside the hurricane evacuation zone A and B, which is the coastal. So they argued then it's not going to impact Siesta Key that much because there's so much more in the mainland. But then as she pointed out, she says, but the 4 hotel proposals, of which 3 got approved, is all on Siesta Key. So that's the reality is the impact is greater in hurricane evacuation zone A because it is coastal. It is a tourist destination. It's what the county was arguing needed hotels. Mm-hmm. So that violated one of the comprehensive plan policies that says you should not encourage hotel and motel development in hurricane evacuation zone A. It actually is encouraging it, because that's where the hotels were approved, and that's where the county admits tourists want to see hotels.
Yeah, I think that the applications that are that have been approved so far, isn't it more than 600 rooms?
Yes, the 3 hotels approved so far is 630 rooms for 3 hotels, and all about 3 acres. If you look at, each one is about an acre. No, I think one of them is 2 acres. But anyway, it's really 4 acres. That's true. 630 units on 4 acres.
On Siesta Key.
Siesta Key.
At least this judge, the hotel applications are limited to Siesta Key. This, to me, you'd have to ask the question, was this a carefully crafted approach that people, drawing it up, legally creating it, understood that, they could say, oh, but it affects the whole county, but they knew that they were opening the door to development, huge hotel development on Siesta Key. I mean, because you've been watching land use decisions and legislation in the county for nearly 2 decades now. Would you say that's a fair question in the minds of citizens, that this was quite deliberate?
I think so. I mean, and even though they tried to make it sound like it was more of a county-wide initiative, the whole point of that change to the code to allow unlimited density the whole focus was to put it on the coast and on the Barrier Island and on Siesta Key. Yeah.
So I've heard a rumor, and if you may not want to comment on this, but there's concern out there that it's not just about hotel development, that there are people wanting to bring gambling to these hotels.
I heard the same rumor. I don't have anything to back that up, but I've heard enough to wonder that that's the whole point. It explains some of the things that was going on, because it wasn't just that we're getting hotels, but they were going to have shops, they were going to have restaurants, they were going to have a rooftop bar. And I couldn't imagine why a hotel would need all of that unless they have a connection to gambling, and they need people to have money to spend on all those amenities. I just couldn't see that. Based on what I heard, though, that was the whole premise. It was just to start bringing in gambling along the coastline.
Yeah, that was something I think often, the rowing facility is a good example of this. You talk about project creep and how something begins relatively simple or innocuous, doesn't look too bad, and then or looks really good, but then it morphs and it changes and it becomes more expensive, or there's different things added to it. The mall out at University and I-75 was a project creep can happen in a different way, where something that's promised is systematically eliminated. So we were promised a walkable shopping center with apartments, where people would live overhead and the stores would be at the street level and people would park, and it would be it was a very sustainable form of development. And then over time, by the time the mall was finally built, it's just the same kind of mall, right? It's not at all. So
yeah, it happened with Siesta Promenade. I don't know if you know of the upcoming hearings in which they're starting to change that approved project on Stickney Point and 41 that got approved in 2019. There's a hearing coming up changing all the stipulations and all the things that they promised they would do or not do. They're changing, so it's becoming more intense, and it was already bad enough as it is. So you're right. Once you do one approval, it's just a matter of time before they change it.
Yeah, that's often the strategy. And everybody, if you're just joining me, you are listening to The Detail on WSLR 96.5 LPFM in Sarasota, Florida, and WBPV 100.1 LPFM in Bradenton, Florida. Do you worry about someone else's drinking but don't know where to turn? Al-Anon family groups can help. Al-Anon and Alateen offer a mutual support program for families and friends of alcoholics. To find a meeting, call 1-888-425-2666 or visit al-anon.org. And with me today is Lourdes Ramirez, who just got very happy news from her challenge of what's been called the mega hotel projects on Siesta Key. The court recently found in her favor that indeed the county did violate the comprehensive plan when they approved those hotels. So I just want to highlight some of the actual verbiage, and it really hinged, Lourdes, that there were some things that you didn't prevail on, and we can talk about them. Hurricane evacuation and population concerns. That was kind of interesting to me to read this. But the new ordinance is called 83-08, and item 96. I'm just going to read from the judge's order. So there's all these findings of facts, and they're listed by number. And there's about 100 of them. And then the judge writes her conclusion that the comp plan was violated. But it says here, neither ordinance 8308, the new ordinance, nor the 1981 plan, which is the photograph we were looking at before, neither one of those prohibits new development on the barrier islands, as the interveners stressed in their proposed final order, and these are the hotel developers. Ordinance 8308 allows a transient accommodation development by special exception in the CG zoning district. Thus, Ordinance 83-08 cannot be interpreted to prohibit new hotel development. The interveners, the hotel developers, are correct on this point. However, the plain language of the 1981 plan explains that the barrier islands are limited to the existing uses and existing maximum densities and intensities of development at that time. New hotel development can take place on the barrier islands, but it is limited to the maximum intensity already on the ground. Intervener's interpretation, expressed in the testimony of its witnesses, is illogical and unreasonable. Good.
Right. Well, that's.
I was like, wow. Okay, good.
It's true. That was one statement that I found pretty incredible, because I felt that way. I really felt that their arguments that hotels can be built at any amount was unreasonable, and it is illogical based on the fact that the old comprehensive. I had things going back from 1960 that talked about you shouldn't develop more on Siesta Key. We're developing too much. And I know she looked at the 1981 comprehensive plan and made it very clear. Barrier Islands is of a special concern. There's concerns about evacuating. There's concern about the destruction of the environment there. And, so what their arguments did seem a little.
Oh my gosh. I mean, I can say it. I just thought it was nuts. I was sitting here listening to it going, you got to be kidding me. So the fact that it's one piece was silent, right? This map didn't place Siesta Key in a certain band. So because it was undefined, that meant there were no rules. And I was just like, well, that, okay, that is what I would expect from, that's the kind of an argument I've heard all these years, and it, thank goodness, thank goodness, actual common sense prevailed here. Another aspect was the coastal policy, and the judge wrote, it's beyond fair debate, and that's the standard that the state goes by, right? That you were referring to. So fair debate is the state standard for comp plan or development disputes. It's beyond fair debate that the ordinance is inconsistent with Coastal Policy 1.2.3. The ordinance is not consistent with and does not further this policy. The ordinance has encouraged at least 3 applications for hotel development on Siesta Key, which is in Hurricane Evacuation Zone A. So that's the first zone that gets evacuated. The parties introduced no evidence that the county has received any application for new hotel development outside of Evacuation Zone A. Interveners' testimony that the ordinance is not inconsistent with this policy because it applies uniformly to all. It's all the county, all CG zone property in the county, and more CG acreage is located outside of zones A and B, was neither logical nor reasonable. I mean, that was another, my word, cockamamie argument that I was just sitting there going, again, really? You got to be kidding me. Lourdes, after all these years, and I mean, this is pretty gutsy, and it's not over, it's not over. I know some people, you may know, there's one friend that comes to mind that said, Siesta Key is gone. It's not, it's just gone. Forget it. It doesn't matter. And, you're not going to, just saying, don't fight it. And my thought was, okay, it's definitely different than it was. It's not the same. It doesn't have the same feel or vibe that it used to. And people will point to Siesta Key in local discussions and conversations with friends, and as an example of what they don't want happening on Lido Key or Longboat Key, right. But that kind of thinking just assumes that it can't get any worse. And it can, right? I mean, what they're proposing is it can get worse. I have to ask you, most people wouldn't put themselves out there to do this. Why did you do it?
I know I get a lot of people really concerned in the beginning, like, if you lose this, you're at a financial risk. But I just knew I was right. I knew, as you know, I've been following the zoning code and comprehensive plan for 20 years.
Yeah.
And especially Siesta Key, although I paid attention countywide, it was, I had a particular focus on Siesta Key, and I knew this was completely wrong. And it was that determination that says, okay, I can't let this go, because you let this go. And what's the next step? What else are they going to loosen up? Density limits on the residential areas? I mean, what are they going to do next? That's what worried me, as well as the fact that they shouldn't violate the comp plan. That would impact the entire county, frankly. If you allow the county to violate the comp plan and they get away with that, how many times are they going to do it? And so I had to do it, and I took the risk. And I must admit, I was nervous throughout.
Sure.
And I did a lot of fundraising to help out with the financial costs, but I knew at the end it's still going to be on my shoulders. And I'm just so glad it turned out the way it did, because I just knew what the county did was wrong, and they had to be called out on it.
Yeah. Yeah. I mean, when the comprehensive plan says that the density and intensity on Siesta Key cannot exceed what was there in 1989, it's very black and white. I mean,
yes, that's how I felt. And so actually, it took me by surprise as we went down the hearings, both in the state case and the local circuit court case, of all the arguments that popped up that I never would have thought would have come into light, with all of these theories by the interveners and by the county of why it should be allowed. I was like, well, where did they come up with that? But they did, and put it forth. And but to me, it was always been very clear.
Yeah, I mean, the folks who want to develop hotels stand to profit tremendously, right? I mean, the difference between a 26-room hotel and 170 rooms, that's a big, that's a big difference. And so they're really motivated and will spend a lot of time and resources to get what they want through.
Especially since in order to get a liquor license, you need more than 100 units in a hotel. Okay. That's the only thing. That's the state rule. That's not a local rule. That's a state rule. And so they were motivated to at least get over that 100 unit count on an acre, or whatever small parcel they can come up with, so they can get a liquor license, so they can have that rooftop bar.
Yeah, and that's often a strategy too, is ask for way more than what you need. And then as your site plan proposal comes in, and maybe there's parking issues, you can back it down a bit, but you'll still be above where you really want, right? You'll still be above the number for a liquor license is 100 rooms. I didn't know that.
But that's true, because we hear that a lot, right? What the developers like to do is says, we'll ask for the moon and the stars. And then when they say, okay, we'll ratchet it back a little bit, they're still getting 4 or 5 times more than allowed. Yeah, but then they phrase it as, we decrease the density.
Yeah, right. That's really fun. And the thing is, if it's a good project, you're not going to see a lot of opposition, oftentimes. I mean, that's not always true, but I think people in this community are pretty reasonable, smart, when it comes to these issues. Lourdes, the judge did not find that the hurricane evacuation argument made sense. And I thought it was interesting because, obviously, as a practical matter for people who live on Siesta Key, I believe there are 10 to 11,000 dwellings, and about 60% of those, 6,000, are full-time residents. I was surprised. The proportion is pretty high on Siesta Key for who's here full-time. So we've seen the traffic at Siesta, at Stickney Point and 41, how people using the South Bridge can be stuck for a very long time to get on the Key. And the same can be true on the North Bridge. So you were arguing that the population of tourists is part of the population under, Sarasota County policy that has to be considered when you're moving people off of the island in a hurricane. And what the judge said is actually the county doesn't include, the policies don't address or include tourists. It's just residents, right? And it changes with the seasonal residents when they come in. So can you explain that? And is there a way that, moving forward, I know you don't necessarily want to show your cards on the radio, but do you think there's more argument to be made there about evacuation and not overpopulating with hotel rooms?
Yes, and a lot of what she based on is the expert by the interveners who said that the county not only does not include tourists in their numbers of what truly is a population, but that the county has reduced the hurricane evacuation time since 2015. And then they showed
she goes through all those numbers.
Yeah, she goes, so when I said it's true, the interveners admitted that they're increasing hurricane evacuation times de minimis, meaning just a few minutes. So not a lot, but still, if the policy says do not increase hurricane evacuation times, my argument was, well, they admit that they increase hurricane evacuation time, even by a few minutes. But since the expert says, but we reduced it over the years, so we're not increasing it, that's where she says, okay, that's where the fair debate comes in. Did the county actually increase it if you already reduced it? So if you had, I think it was 69 hours back in 2015 as the hurricane evacuation time for Siesta Key, and they reduced it to 59, even if they reduced it a few more minutes, increased a few more minutes with this proposal, then they still overall reduced the hurricane evacuation time since that time. And that was her fairly debatable standard use for that particular argument. So she could see how my argument that they increased hurricane evacuation time really doesn't make a difference if they overall decreased it over the years. But the only problem was I didn't have a hurricane expert to refute that. So she had to rely on their testimony.
Okay. What happens now? I mean, your attorney, Richard Grasso, who is a leading attorney in the state of Florida. He's been on my show talking about this case as well as the case out east regarding the development that was approved in our rural area, which again appears to violate the comprehensive plan. So, and by the way, he told me, you are the most educated client he's ever had. He's like, she knows she knows her stuff. I'm like, I know Lourdes has been doing this. Yeah, he did say that, that you've been doing this for a long time, but this is one step in a process, right? So you've got the comprehensive plan, and you're also challenging the individual approvals. So what now? I mean, they're going to appeal, right? You expect an appeal to this ruling, or?
They have 30 days to appeal. Both the county can appeal or the interveners. And, we always expect that they might. We don't know what they're going to do. And that's that step. And then, of course, I still have the circuit court case in which we challenged the actual approved hotels, because the state was the challenge of the zoning ordinance change. And the circuit court case is challenging the actual approved hotels. And we still have hearings coming up on that. I had a motion for summary judgment on that in front of Judge Walker. He had recused himself for conflict with because of a professional relationship he had with the clients of another hotel. And now we have a new judge, Judge Hunter Carroll, and there's a hearing before him in April 20th. And we're not sure. We kind of have to find out how he wants to handle the motion for summary judgment. Does he need another hearing? We don't know what's going to happen.
Yeah.
So
okay.
I'm glad that
in other words, this isn't over. It's a big win.
It's a great win. And,
Yeah.
I mean, I really feel like someone listened to the citizens.
Mhm.
And so big win for Siesta Key. We haven't had a big win on Siesta Key in almost a decade.
Well, and
And
for the county too, as you said, because
yeah,
of such a flagrant violation of the comp plan was allowed to stand, it really would have impacted everybody.
I think I agree with that, because if you let the county violate the code and get a comprehensive plan and get away with that, how many times are they going to do it? Although after I filed my lawsuit, I've gotten neighborhoods calling me saying they did it over here too, but it wasn't challenged. And so
You have to,
we have to
yeah.
wait to see if they appeal this issue while we still go down the path of the circuit court case. And that's really complicated.
How many cases are there? Is there, for the circuit court cases, is it 2 hotels you're challenging? And you're not the only one. Aren't there other people challenging as well?
Yeah, with the state case, it was just my challenge. But in the circuit court cases, there's 2 lawsuits that got consolidated recently. And my lawsuit had to do with the Cayo Miramar, which is the village hotel that was approved. And the other case had to also do with that, but also includes the one on Stigney Point on Siesta Key, Old Stigney Point Road. And that's the one in which they got 120 units on 1.2 acres. And those plaintiffs includes Rob Sachs and 2 condos, Marina del Sol and 222 Beach Road. So there are 3 plaintiffs there, and then my lawsuit. So there's 2 going on that direction. And we're still waiting to see how that's going to be handled. And right now, the trial date for that one is scheduled for October, but there'll be things happening before then as we try to figure out how to handle.
Yeah. So there was all this question, or, the respondents were claiming that, trying to say that you didn't have standing. Standing is always a way to kind of make a lawsuit go away, because if the plaintiff doesn't have standing, then, you make it go away. I'm curious about, because you're saying that 2 condo associations are challenging the hotel approval at Old Stigney Point Road. Do they have any issues with standing that you're aware of, or is it considered?
No.
Okay.
It's considered. There has been court cases in which not only homeowners associations and civic organizations, but even organizations that have to do with the environment can have standing in challenging land approvals. I think there was a court case on the other side where somebody was, it's not an Audubon, but it was a animal activist group who was given standing to challenge a development near a very, very sensitive environmental area. So it could be groups. It could be. Okay.
All right. Well, if people want to learn more, or, support your lawsuit, if they'd like to go to a meeting, where would you direct people who want to follow this and understand what the next steps are and how they can support your effort?
Yes, I have a website. It's siestakeycommunity.com, altogether.com, siestakeycommunity.com. And that's where I will be updating it soon about all the new information that's coming through, but that's where you can get a lot of the information about my efforts.
All right. Well, Lourdes Ramirez, thank you for making the time to explain this to us. Is there anything you want people to know that we didn't touch on, or you?
I still want to thank all the individuals who came out to support, and it's amazing how many people reached out to me when I won. I heard people from Costa Rica to Maine.
Oh wow!
People who were just so happy to hear that finally the neighborhood advocate in Siesta Key, we won. I think of it as we won, not just I won. I think we won, and it's something we all needed to hear, I think.
Well, you really did do something on behalf of the whole community, and there's people all over the country that love Siesta Key, that come and enjoy it and have seen the changes. And we need some growth. Maybe there's a lot of people who feel it was too much, but but we're on the brink of something huge if it were allowed to move forward. And so I'm not surprised actually that you heard from so many people. I think these days in Florida, there's a lot of concern about our future. So thank you for racking up a win for our community.
Thank you for letting me explain it. And I really
Yeah.
appreciate you letting me on the show.
Absolutely. So everybody, thank you so much for listening. You've been listening to The Detail on WSLR 96.5 LPFM in Sarasota, Florida, and WBPV 100.1 LPFM in Bradenton, Florida. If drinking is no longer fun for you and separates you from other people, you can attend an AA meeting. They've been there. More information is available by phone at 941-951-6810 or online at aasrq.org. Be sure to stay tuned for more public affairs programming here on WSLR. Make it a great day.